Someone make it make sense.
Probably a couple.
Good morning, squirrel friends. How is everybody doing today? Or good evening or good afternoon, depending on where you're joining us from. Happy to be here. Woke up this morning and, as per usual, checked the docket, and sure enough, we've got some new court filings. So first of all, we are going to start with an old court filing, but it's actually going to be really relevant to one of the new court filings. So this is from April of 2023. And so we have comes now, this is from the state. So the Latah prosecuting attorney, Bill Thompson. So I petitioned this court to appoint Deputy Attorney General Jeff Nye and Deputy Attorney General Ingrid Beatty as Special Assistant Attorneys General to assist in the prosecution of State v. Kohberger. I seek assistance in this case in order to utilize the expertise and additional resources of the Office of the Attorney General. And the Attorney General's office has agreed. So in other words, this was when he was asking for additional help from the Attorney General's office. Of course, it was granted. Okay, so that was from April 2023. Now we're going to go to the first of the new court filings here. So this just came in, and it was filed on the 19th, but just came onto the docket. So now we have amended petition for appointment of Special Assistant Attorneys General. So this is very much the same, right? The first 2 points here. Then this says, I have sought assistance in this case in order to utilize the expertise and additional resources of the Attorney General. The Attorney General's office has agreed in writing to assist the Latah County Prosecuting Attorney's Office in this matter. Pursuant to the written agreement, the Attorney General's office agreed to pay the salaries of its personnel who assist in the prosecution. The nature of this case and its prospective duration may require the transition of assigned Deputy Attorneys General to meet staffing needs. And then I petitioned this court to amend the appointment filed herein on April 24th, that's when we just read, to appoint the chief of the criminal law division or his designee as a special assistant attorneys general to assist in the prosecution of State v. Kohberger, so as to facilitate the prospective transition of assigned deputies, attorneys general as may be appropriate. So what this means is they're asking for more help. The state says we need more attorneys, we need more help, we need more resources, and that's what Bill Thompson is asking for here. Okay, so that's the first thing. And then the big one, we have the memorandum decision and order on death penalty motions. This was filed on November 20th. Again, just came onto the docket. Okay, so we're going to skip like the introduction, right? Okay. Okay, standards. The constitutionality of Idaho's capital punishment scheme is a question of law. State v. Abdullah, which we have seen cited in the other court filings regarding the death penalty. When a party challenges a statute on constitutional grounds, it bears the burden of establishing that the statute is unconstitutional and must overcome a strong presumption of validity. Further, when considering these challenges, courts are obligated to seek an interpretation of a statute that upholds its constitutionality. That's important. So let me read that again. Further, when considering these challenges, courts are, quote, obligated to seek an interpretation of a statute that upholds its constitutionality, end quote. And we know that, like, we know that it's normal for judges to not want to rock the boat, so to speak. They are more than likely to uphold previous rulings, things of that nature. But this is specific as it relates to constitutionality. So this is saying that the courts are obligated. In other words, they have to try to find an interpretation that upholds the constitutionality. So that's important. The interpretation of a treaty is a question of law, as are matters of statutory interpretation. Whether there is an infringement of a defendant's right to a speedy trial presents a mixed question of law and fact. A reviewing court will defer to the trial court's findings of fact if supported by substantial and competent evidence, and will exercise free review of the trial court's conclusions of law. A motion to trifurcate capital proceedings is a matter of discretion. So what he's already outlining here is the different standards for each category of these different death penalty motions, right? Because we have, for example, we have the treaty. That was like the international treaty, right? He says that's a matter of statutory interpretation. Then we have the speedy trial motion, right? And he's saying that's a mixed question of law and fact. Then we have the motion to trifurcate, and he's saying that's a matter of discretion. So these are all different standards. Consequently, a trial court must, 1, correctly perceive the issue as one of discretion, 2, act within the outer boundaries of its discretion, 3, act consistently with the legal standards applicable to the specific choices available to it, and 4, reach its decision by the exercise of reason. Analysis. Motion to strike state's notice on grounds of arbitrariness. Defendant moves to strike the state's notice on grounds that Idaho's capital sentencing scheme fails to narrow the class of first-degree murders who are death-eligible defendants, thus permitting an arbitrary and capricious selection of defendants for death. He further argues Idaho's scheme is unconstitutional due to geographic disparities as to who is selected for the death penalty. These infirmities, according to the defendant, violate his Eighth Amendment protection against cruel and unusual punishment and other rights as well. In support of his argument, defendant relies in large part on a study conducted and published in a law review article by Professor Eliza Cover. And that was one of the witnesses who they wanted to have present testimony during that hearing on the death penalty motions, and it was not allowed. In response, the state contends that both arguments are foreclosed by binding precedent. It further argues that Professor Cover's article should be afforded little, if any weight, given foundational issues and lack of relevance. That's what the state is contending. So, constitutional requirements of a capital punishment scheme. In imposing capital punishment, Idaho has a constitutional responsibility under the 8th and 14th Amendments to the U.S. Constitution to tailor and apply its laws in a manner that avoids the arbitrary and capricious infliction of the death penalty. To accomplish this, Idaho's capital sentencing scheme must provide a meaningful basis for distinguishing the few cases in which the penalty is imposed from the many cases which it is not. So again, this is the narrowing. We've talked a lot about this on previous live streams. It's like the worst of the worst, right? Well, what does that mean? And that's where you need to have objective ways to narrow that class. Constitutional review of a state's capital punishment scheme addresses two separate aspects of the decision-making process: the eligibility decision and the selection decision. States must comply with requirements of both their respective schemes to be constitutional. Eligibility standards. The eligibility decision imposes a narrowing requirement on a state capital scheme. To pass constitutional muster, a capital sentencing scheme must genuinely narrow the class, right? We have seen this, we've read this. State legislatures can satisfy the narrowing function in one of two ways. 1, by narrowing the definition of capital offenses, or 2, by more broadly defining capital offenses and providing for narrowing by jury findings of aggravating circumstances at the penalty phase. For states that have attempted to satisfy the narrowing requirement through the enactment of statutory aggravators, the United States Supreme Court requires. And I'm wondering, can you guys see my cursor, hopefully? Because I'm trying to have my cursor so that you guys can read along too, if you can see it on the screen. Let me know if you can see my cursor or not see my cursor. The trier of fact must, so this is from the United States Supreme Court. The trier of fact must convict the defendant of murder and find one aggravating circumstance or its equivalent at either the guilt or penalty phase. The aggravating circumstance must meet two requirements. First, the circumstance may not apply to every defendant convicted of a murder. It must apply only to a subclass of defendants convicted of murder. And second, the aggravating circumstance may not be unconstitutionally vague. That's really important. Oh, you know what? I'm wondering if you guys can't see it. It's not letting me. Hold on. Let me share this. Let me share this a different way. Hold on, so that you guys can see this, because I was going to highlight this because this is important here. Hold on. Give me one sec. Here we go. Let's see if this makes a difference. Okay, perfect. This is what I wanted to be able to do. I wanted to be able to highlight this. Shout out to Frankie Fakes, glad you're here, my friend. Shout out to any other STSers as well. So this, second, the aggravating circumstance. Oh, let me highlight. There we go. Okay, second, the aggravating circumstance must not be unconstitutionally vague. Now that matters because, as we've discussed, a lot of these aggravating circumstances do seem vague, right? I'm speaking especially to the HAC aggravator, heinous, atrocious, or cruel, and the utter disregard aggravator, because they're essentially the same and both very vague and arbitrary and subjective. So we've talked a lot about that on this channel. So it'll be interesting to see what comes of this standard here as designated from the United States Supreme Court. That said, if a particular statutory aggravator is vague, state courts are permitted to further define the aggravator through limiting construction so as to allow the state to meet its constitutional obligation to provide some guidance to the sentencer and avoid the arbitrary and capricious infliction of death. All right, now we have the selection standards. So the selection decision aspect of capital sentencing determines whether a death-eligible defendant should actually receive the death penalty. This phase requires individualized sentencing and must be expansive enough to accommodate relevant mitigating evidence so as to assure an assessment of the defendant's culpability. What is important at the selection stage is an individualized determination. Why don't you let me highlight? Adobe. Okay. An individualized determination on the basis of character of the individual and the circumstances of the crime. So that's two-pronged, right? The character of the individual and the circumstances of the crime. That requirement is met when the jury can consider relevant mitigating evidence of the character and record of the defendant and the circumstances of the crime. Okay, now as it comes to the Idaho Supreme Court. So the Idaho Supreme Court has found Idaho's capital scheme to be constitutionally narrow. Idaho has opted to satisfy the constitutionally imposed eligibility requirements through the adoption of statutory aggravators, in addition to statutorily carving out a class of murders, i.e., first degree, to which the death penalty may apply. Under Idaho law, first-degree murder is a potentially capital crime. If such person killed, intended a killing, or acted with reckless indifference to human life, irrespective of whether such person directly committed the acts that caused death. If an individual falls into this category, at least one of the 11 statutorily enumerated aggravating circumstances, several of which are subject to limiting constructions, must be found beyond a reasonable doubt for the individual to be death eligible. So what this is referencing, so in Idaho, right, when it comes to the death penalty, they've got 11 statutory aggravating circumstances, okay? And as we know, they started out with 5 here in this case, right? 5 aggravating, and remember, the burden for the state when it comes to the sentencing phase, the penalty phase, the burden is on the state to prove at least 1 beyond a reasonable doubt. And initially they had 5. However, maybe 2 weeks ago or so, I covered it, of course, the state dropped one of the 5, and it was the felony murder aggravator. So they're down to 4. So that's a big win for the defense, because if all this, we're going to find out what's going to happen, right? But if indeed it goes through, if indeed he's convicted, right, and it goes on to this penalty phase, now they've got only 4, right? Because again, they have to prove 1. So if you're the state, the more the merrier, right? You want to have as many as possible, because then your odds increase that the jury will find at least 1 beyond a reasonable doubt, and that's the standard. So they have 4 now, okay? So that's important. Defendant contends Idaho's scheme has so many aggravating circumstances, so broadly construed that the aggravators accomplish no narrowing and create a greater risk of arbitrary death sentences. However, the Idaho Supreme Court has determined that Idaho's approach accomplishes the narrowing function in the eligibility phase as required by the U.S. Constitution. Noting that while a particular aggravator may apply to many murders, the court has concluded that no one aggravator applies to every first-degree murder. So that's what they're saying. That's the logic here from the Idaho Supreme Court. They're saying that the way that it accomplishes the adequate narrowing that's necessary is that not every aggravator will apply to every first-degree murder. Moreover, in challenging Idaho's scheme, defendant improperly focuses on the statutory aggravating factors in the aggregate rather than individually. This approach was rejected by the Idaho Supreme Court. So it's not looking good so far. There, the defendant argued that the combination of all statutory aggravators applied equally to all first-degree murder defendants and therefore did not provide a meaningful distinction, and that's the standard, that meaningful distinction, right, between those deserving of the death penalty and those who were not. The court found no legal basis for considering the aggregate effect of Idaho's aggravators, noting that each aggravator must be considered individually. Because the defendant failed to challenge any one particular aggravating circumstance, this is not here. I just want to make a distinction. That's not this court. This is in this case from the U.S. Supreme Court. Aravi, I guess. That's not here. So what they're saying is in this U.S. Supreme Court case law, in that case, the defendant failed to challenge any one particular aggravating circumstance, so the court refused to find Idaho's capital scheme arbitrary. So I just want to make the distinction because here they did challenge every particular aggravating circumstance. Okay. So defendant contends, however, that Hairston did not reach the question of whether Idaho's statutory scheme as a whole failed the narrowing function. Rather, he contends the court's ruling was on whether a court could still determine who deserved death, not on whether the statutory structure had failed the narrowing function. Defendant points out that at the time of Hairston, judges, not juries, could still determine whether to impose the death penalty, right? Because that used to be the case. Right now it goes to the jury, but it used to be the judge. Thus, defendant posits that whether Idaho's statutory scheme as a whole has provided sufficient narrowing to prevent juries from arbitrarily imposing death is a matter of first impression. Defendant's attempt to distinguish Hairston is misplaced. Ouch. The court squarely held that there was no basis to consider whether the aggravators collectively performed the narrowing. Rather, the relevant question was whether the applicable aggravator individually performed the narrowing. Defendant has provided no basis for why the analysis should be different when a jury rather than a judge makes the determination. Indeed, I'm not going to read all this about Tulipa. Okay, additionally, while the Eighth Amendment's narrowing analysis is typically confined to the eligibility phase, the narrowing effect of the selection phase and mandatory appellate review that focus on who ultimately receives the death penalty cannot be ignored. Bunch of case law here. For a death penalty scheme to be constitutional, both the eligibility phase and selection phase must contain safeguards to ensure that the process is neutral and principled so as to guard against bias or caprice in the sentencing decision. If the death penalty, okay, actually, I'm going to read this. So anyone that followed and watched Chad Daybell, we heard this, but just I'm going to go reiterate this because the way Idaho does this is unique here. So Idaho's selection phase requires that the jury weigh all mitigating circumstances against each applicable aggravating circumstance and determine whether the imposition of the death penalty would be unjust. So I think that, that's a good way to do it for the jury, right? So in other words, the jury's job is not to say, does he deserve the death penalty, right? Their job is to say, would it be unjust? It's kind of like a glass half full, half empty type of thing, where the way you look at it so that they don't feel like they're saying someone should die, deserves to die. They're having to look at it from the opposite end and say, can we say it would be unjust to not give them the death penalty, if that makes sense? The jury must unanimously agree that the death penalty is warranted. If the death penalty is imposed, the sentence is then reviewed by the Idaho Supreme Court to determine, one, whether the sentence of death was imposed under the influence of passion, prejudice, or any other arbitrary factor. Before I go on to point two, I'm just going to say, can you see, guys, how victim impact statements, if they're given during this presentation of the state's evidence, right? So the state's going to present their statutory aggravating factors, right? If they also present non-statutory aggravating factors, that is victim impact statements. Can you guys see how if they present that before the jury then goes to deliberate about the death penalty, can you guys see how the victim impact statements could possibly influence the jury, right? Influence of passion, prejudice, or any other arbitrary factor. I would say emotion. Yeah, emotion. Hatred, vengeance, all of those emotional things. And that's what happens with victim impact statements is they're emotional. And in my view, I don't see how it should be a factor in terms of determining a sentence, death penalty or otherwise. So now for number two, and whether the evidence supports the jury or judge's finding of a statutory aggravating circumstance. Thus, importantly, eligible defendants are further narrowed through these phases, which defendant's argument does not consider. This part about the geography, I'm going to skip because this is kind of just going through like the historical, and we did cover all of this in the defense's motions, on previous live streams. And while it was interesting and there was a lot of history and all that, as far as the geography, that was not a strong argument, in my opinion. A motion to strike individual aggravators. The state has identified four, again, because they dropped four statutory aggravators in its notice. Okay. So the first, this is the multiple victims, right? These are the four statutory aggravating factors. At the time of the murder was committed, the defendant also committed another murder. That's the multiple victims. I don't think there's anyone that's going to deny that, right? That to me is an objective aggravator. It narrows the class. And I think this is a fair standard if you're going to be doing all this. Like, I think this is fair. But we're going to see some differences as we go along. All right. Now we go to the HAC aggravator. The murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity. I mean, even if you don't call it vague, it's completely subjective, first of all. And we've talked a lot about this aggravator on this channel. I'm not going to go into it, but that's the HAC aggravator. And then we have my other least favorite, the utter disregard. By the murder or circumstances surrounding its commission, the defendant exhibited utter disregard for human life. And by the way, when I did cover all of these, when these motions were filed, I pulled up the statutes for these. And what was so, I would say funny, but I'm being sarcastic, it's not funny at all, is that when they look at the definitions, and this is in the jury, and this will be in the jury instructions, okay, when they give this to the jury, the definition for utter disregard for human life, and then the definition for heinous, atrocious, or cruel, they were like exactly the same thing. And it was like, I don't remember exactly what it was. It was like exceptionally evil or something. Again, doesn't help at all, completely subjective, doesn't actually mean anything. And vague, I would say. And then the last one, the defendant by his conduct, whether, so this is the propensity, right? The future dangerousness factor. The defendant by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute. Now, where I see this being relevant is if you've got a serial killer, right? Like name a serial killer, pick a serial killer, any serial killer, right? There, yes, because that makes sense. Future dangerousness. Now, however, having said that, my issue I take with this is that how does it protect the public? Because when we're talking about future dangerousness, right? How does it protect the public anymore to kill somebody versus put them in life without parole? So I take issue with it from that standpoint because this makes no sense. You know, when we're looking at, the future dangerousness, again, take a serial killer, for example, that I can see, life without parole, because if they get out of prison, right, they probably could kill again or probably would kill again, right? Now, of course, that's not what we have here in this case, but nonetheless, where it doesn't make any sense to me is that means you need to kill them, because if you say that that's the case, then we need to really ramp up the security on these prisons, right? Through 4 separate motions, defendant seeks to strike each of the foregoing aggravators for various reasons. The court finds none of the defendant's arguments to be prevailing. So I think we are getting some signaling here from Judge Stickler, as I call him. Also, I have called him Judge Grinchler. Maybe we'll save that more for when we get towards the holidays. But Judge Stickler, Judge Grinchler, Judge Hippler, same guy. He's signaling here. The court finds none of the defendant's arguments to be prevailing. Now, here, this is specifically as it pertains to these motions to strike the different aggravators. It'll be interesting to see when we get to the motion to trifurcate, because I feel like there was a really strong case there for that argument to be made there. That was made. So the utter disregard. The utter disregard aggravator applies when, by the murder or circumstances surrounding its commission, the defendant exhibited utter disregard for human life. You know, the thing is, again, I'll just point out, right? Does this narrow the class, right? Does this narrow the class? We have to think about this. Why won't you highlight? Come on. Because here's the thing. Couldn't one say that anyone that murders another person, unless it was like self-defense, right? You know, or I guess you could say if they're, you know, if you're going with like an insanity defense, right? But under most circumstances, right? Wouldn't one say that anyone that takes another life has exhibited utter disregard for human life? I mean, you know. All right. I love this one. By love, I'm being sarcastic again. Here's how they define it in State v. Osborne. This is from the Idaho Supreme Court. The phrase is meant to be reflective of acts or circumstances surrounding the crime which exhibit the highest, the utmost callous disregard for human life, i.e., the cold-blooded, pitiless slayer. Y'all, you know, I hope it speaks for itself before I go on a rant. Okay. In moving to strike the aggravator, defendant argues that Osborne's limiting construction, or judicial gloss as he characterizes it, is unconstitutional as it violates the separation of powers. He additionally argues that the Idaho criminal jury instruction, and that we reread those, like I just referenced, actually. Here, keep reading, Chelsea. The definitions. Yay. Here we go. For anyone that missed it, we're going to get them here. Defining the utter disregard aggravator overlaps with the HAC. You know what this is? You know what this is? Hang on. This is this. This is this. Shout out to the Squirrely crystal ball. All right. Yeah. Okay. And ignores the alleged legislature's intent that the killing be done recklessly. Neither argument has merit. Oh, please go on to define it, though. Is he not even going to include the definitions? Well, again, I did pull up those statutes and I did read them, and they were almost identical. It was sad. There's no dispute that Idaho's utter disregard aggravator has consistently been upheld as constitutional. And remember, like I pointed out initially at the very beginning of this, like I said, remember that whole thing that, let me actually go to it again. So we're on page 12. Let me go back here to here. Okay. Courts are obligated to seek an interpretation of the statute that upholds its constitutionality. So every time we see Judge Stickler mention that something has been found to be constitutional, that matters, because basically he's going to deny the motion because he's already set out that is his job. He has to uphold the constitutionality, right? So it's already been upheld as constitutional. Specifically, the court found it unnecessary to decide whether the statutory language itself passed the constitutional muster, concluding that Osborne's limiting construction adequately channels sentencing discretion as required by the 8th and 14th Amendments. In ordinary usage, then, the phrase cold-blooded, pitiless slayer refers to a killer who kills without feeling or sympathy. These terms, the court observed, describe the defendant's state of mind, not his mens rea, but his attitude toward his conduct and victim. This is not a subjective matter. I completely disagree. It's completely subjective. I don't understand how you can say it's not subjective, and be honest with yourself. Likewise, the Idaho Supreme Court has repeatedly reaffirmed the constitutionality of utter disregard aggravator with the Osborne limiting construction. So I would say that here's what I would say. Judge Stickler, I don't know that he would have agreed with any of the defense's arguments. However, even let's just say hypothetically that he did, I think that his hands would be kind of tied here because of the fact that he has to uphold anything that was found already previously to be held as constitutionally, as constitutional, right? If it was previously found to be constitutional, he has to carry that on. And so it's almost like his hands are tied. Defendant, however, argues that Osborne's limiting construction violates the separation of powers. I'm not going to go through the separation of powers here. So, oh, good. Here we go. Now, well, we do get the definitions. Excellent. All right. This is it. This is from the Idaho jury instructions that we read. The utter disregard standard is set forth in the Idaho criminal jury instructions. It states, exhibited utter disregard for human life with regard to the murder or the circumstances surrounding its commission refers to the acts or circumstances surrounding the crime that exhibit the highest, the utmost callous disregard for human life, i.e. the cold-blooded, pitiless slayer. Cold-blooded means marked by absence of warm feeling. How can anyone possibly determine what someone else is feeling without, getting inside their head? Without consideration, compunction, or clemency, matter of fact, or emotionless. How can someone say that someone was or wasn't feeling emotions? Pitiless means devoid or unmoved by mercy or compassion. Now, that I think is less bad in the sense that, leaving someone to die, for example, would be an example of like let's say you could have saved them and you didn't, that type of thing. Great example would be Ezra McCandless, because the evidence was borne out that had she actually called for help, he could have, Alex Woodruff could have survived. A cold-blooded, pitiless slayer refers to a slayer who kills without feeling or sympathy. The utter disregard factor refers to the defendant's lack of conscience regarding killing of another human being. I mean, right here, while Idaho criminal jury instruction 1713, I think that's the HAC. Yeah, the HAC aggravator also focuses on a defendant's state of mind in instructing on the HAC aggravator. Right. Do you guys see why that's problematic? This is the jury instruction, and the instruction has to do with the defendant's state of mind. It's impossible unless they write a note or something saying, here's what I'm thinking and feeling right now. How can you possibly put that before a jury? Shout out to Needs, since he's glad you're here. Right now, this judge is admitting, conceding that so far from what they've discussed, there's two statutory aggravating factors that provide the jury with jury instructions that focus on the defendant's state of mind. So between giving a jury, when it comes to the sentencing phase in a death penalty case, between giving the jury instructions that say, try to get into the defendant's head and what they were thinking and feeling at the time, between that and then allowing in victim impact statements that are emotional, none of this, right, seems like this, and that's another thing. I'll just point out for anyone that missed it, we have learned through these other motions and court filings that the rules of evidence don't apply in the sentencing phase. Clearly, right? I would say. Okay. Okay. Together, these instructions ensure that to the extent there is potential for overlapping evidence between the utter disregard and the HAC aggravators, the jury is to consider it only once. As for the defendant's recklessness argument, had the legislature intended to import this standard into the utter disregard aggravator, it could have done so with 2 other statutory aggravators. The fact that it did not indicates the legislature intended a different standard to apply than recklessness. In sum, the court finds limiting construction applied by the Idaho Supreme Court to the utter disregard statutory aggravator does not contravene the separation of powers doctrine or does not misconstrue the statute, blah, blah, blah. Defendant's motion is denied. Again, he had signaled that. I think we saw that coming. HAC aggravator. The HAC aggravator applies when the murder was right. We've already read that. Regarding the, here we go, guys. One of my other favorite, again, being sarcastic, regarding the especially heinous, atrocious, or cruel portion of the aggravator, the court adopted the following language from the Florida Supreme Court. So I do partially blame Florida for this. All right, you guys ready? Get ready. I think I need to get my goat ready, comfort goat. Because yeah. All right, so heinous means extremely wicked or shockingly evil. That atrocious means outrageously wicked and vile. So wicked's are even used twice. And I love the words like shockingly, outrageously. Again, it's completely subjective, and these are more emotional reactions, right? And that cruel means to designed to inflict a high degree of pain. That is less subjective, right? Because one could say, yeah, stabbing, obviously, right? With utter indifference to or even enjoyment of the suffering of others. What is intended to be included are those capital crimes where the actual commission of the capital felony was accompanied by such additional acts as to set the crime apart from the norm of felonies. Oh, and look again here, the conscious or pitiless crime. Oh, does that sound much like pitiless slayer? I think it does, which is unnecessarily torturous to the victim. With regard to the manifesting exceptional depravity portion of the aggravator, the court adopted the following from the Nebraska Supreme Court. In interpreting this portion of the statute, the key word is exceptional. It might be argued that every murder involves depravity. And I think I made that I made a similar argument with something else. The use of the word exceptional, however, confines it only to those situations where depravity is apparent to such an extent as to obviously offend. All right, guys, hold on. Why won't you let me highlight again? Please, let me highlight. Why won't you let me highlight? Hold on. Okay, Adobe is having a day. Where did it go? Hold on. Okay, please work. Okay, so here we go. Exceptional, however, confines it. Why won't you let me highlight it again? Confines it only to those situations where depravity is apparent to such an extent as to obviously offend all standards of morality and intelligence. Hold my tongue. The court found this limiting construction removed any vagueness from the HAC aggravator. Of course it did. Rendering it sufficiently definite and limited to guide the sentencing court's discretion on imposing the death penalty. And everyone else agreed, because that's what they do. They agree. They agree. One person makes a decision, or one court makes a decision, and then everyone else is like, yep. We're not going to muddy the waters. We're not going to rock the boat. We're going to just agree. As with the utter disregard aggravator, defendant contends the HAC aggravator must be stricken because The limiting construction violates the separation of powers for the same reason that argument failed for the utter disregard aggravator fails here. And again, I'm not going to go over the separation of powers thing. But here we go. Consequently, defendant's motion is denied. All right. So far, we've got 2 motions denied. That's the motion to strike the utter disregard aggravator and the motion to strike the HAC aggravator. Denied. Next up, the future dangerousness aggravator. Right. Exhibited a propensity to commit murder and will probably constitute a continuing threat to society. Again, I say, won't LWOP also accomplish that same goal? Would it not? What do you guys think? LWOP, like, do you think they can still be a threat to society if they're in custody the rest of their lives? We would construe propensity to exclude, for example, a person who has no inclination to kill but in an episode of rage, such as during an emotional family or a lover's quarrel, commits the offense of murder. We would doubt that most of those convicted of murder would, again, commit murder, but rather we construe the propensity language to specify that person who is a willing, predisposed killer. That's interesting. This says we would doubt that most of those convicted of murder would again commit murder. That's interesting because I feel like whenever you watch murder trials, that no one ever says that, right? Maybe the defense, on sentencing would make that argument, but most of the time, don't people get LWOP though? Anyway, a killer who tends toward destroying the life of another, one who kills with less than the normal amount of provocation. Nevertheless, defendant seeks to strike the aggravator on 3 grounds. It's limiting construction, fails to narrow the class, it's impermissibly vague, and it's irrelevant to culpability and therefore cannot be an aggravator. Right, so the defendant contends the limiting instruction applied in Creech excludes only those found guilty of voluntary manslaughter from its reach and effectively makes anyone who's found guilty of murder a candidate for death. He notes that murder is defined in Idaho involvement part S. So how does Idaho define murder? Okay, the unlawful killing of a human being with malice aforethought or the intentional application of torture to a human being which results in the death of a human being. Torture is the intentional infliction of extreme and prolonged pain with the intent to cause suffering. It shall also be torture to inflict on a human being extreme and prolonged acts of brutality, irrespective of proof to intent to cause suffering. Defendant is incorrect that the aggravator and its limiting construction applies to every murder. Creech specifically states that the propensity aggravator does not apply to every murderer coming before the court in this state. Hence, the Idaho criminal jury instruction instructs that, quote, a finding that the defendant has a propensity to commit murder, which will probably constitute a continuing threat to society, cannot be based solely upon the fact that you found the defendant guilty of murder. That's all fine and dandy. I still ask the question, why does that mean they have to die? Why is LWOP not good enough if they're a threat to society? The aggravator is impermissibly vague or confusing. Defendant next argues that the propensity aggravator is impermissibly vague or confusing to the jury, as it applies to evidence of mental illness. Right. Mental illness, however, is supposed to be viewed as a mitigating factor for death penalty purposes. Thus, juries are essentially asked to consider mental illness as both a mitigating and aggravating factor. We talked about this, rendering the evidence a double-edged sword. Right. We talked about this because I was like, yeah, that's a good point. That's wild, right? Defendant points out that juries are confused by the double intention behind evidence of mental illness and typically apply it as an aggravator rather than a mitigator. Thus, he argues it should be stricken. So here's from the United States Supreme Court. It noted that the defendants, now this is an outdated, I'm not going to say it. You guys hopefully can see. Can I highlight it right here? This is an outdated term, right? This is from 1989. This case law is from 1989. So we'll just say, I don't even know. I don't want to try to even think of another swap for that. Limited, in mental abilities. I don't know. You guys in the chat, let me know if there's a better way. I don't even know I can't even think of anything right now to swap out. But, people that have intellectual disabilities, right? And history of abuse is thus a two-edged sword. It may diminish his blameworthiness for his crime, even as it indicates that there is a probability that he will be dangerous in the future. With such double-edged evidence, an instruction must be given to a jury to consider and give effect to mitigating evidence as it bears on the extent to which a defendant is undeserving of a death sentence. Defendant has cited, this is the judge does not like these defense attorneys. Defendant has cited not one case in which the propensity aggravator was stricken as a result of potential jury confusion weighing double-edged evidence. Additionally, as the state points out, the defendant has not filed notice under IC. Right, and that's true, that he will be relying on a mental condition. Yeah, I don't think they're going that route. And there's no indication by either party that evidence of mental illness will be presented at sentencing. Consequently, the motion is not ripe. And even if it were, striking the aggravator is not the solution. Defendant finally argues that future dangerousness is not relevant to culpability and should be stricken. To this end, he observes that the Eighth Amendment requires that defendants only be condemned to die if they are deserving based on their culpability, not their dangerousness. Because a person's propensity to commit murder in the future has no bearing on culpability, defendant contends future, it's sort of like chicken before the egg type of thing, or chicken and the egg. Future dangerousness can only be considered, if at all, after the jury has already found a different statutory aggravator applies. Defendant's argument, however, fails to recognize that a defendant's future dangerousness has long been a sentencing consideration, which places an emphasis on culpability. And hold on, give me just one sec. I'm just updating my next live stream. Okay, because this is going to redirect you guys into the next live stream. And I wasn't sure how long it would take to read this document, so I just moved that back. Okay, so defendant's argument, however, fails to recognize that a defendant's future dangerousness has long been a sentencing consideration, which places an emphasis on culpability. The Supreme Court observed, the court has approved the jury's consideration of future dangerousness during the penalty phase of a capital trial, recognizing that a defendant's future dangerousness bears on all sentencing determinations made in our criminal justice system. As the state points out, the protection of society is y'all already know what I'm going to say about this, right? Protection of society is the primary consideration in fashioning a sentence for a criminal defendant. Yep, agreed. Should protect society. Don't need to kill them to do that. A capital defendant's future dangerousness, therefore, is directly relevant to whether he or she, why does nobody see that this is illogical and makes literally no actual sense? In sum, the court finds the propensity aggravator is sufficiently narrow to encompass only a select set of murderers. The jury will not be misled or confused. Anyway, as we can see here, consequently, the motion is denied. All right, now we're on the last one. This one's not going to be denied because we know there were multiple victims. That's not surprising. Let's just get to the conclusion on that one because, yep, there it is. Consequently, defense motion is denied. Yep, I expected that because that was the one that was like, yeah, that's not going to go anywhere. This one's not going to go anywhere. This is the one that I said was one of the weakest of all the motions. So this is the one where they're saying that they needed to present evidence, the aggravating evidence to a neutral fact finder, and by which they mean the grand jury. And we know Jay Logsdon loves a good opportunity to talk about the grand jury, right, whenever he can. This is not going to go anywhere. There's just no way. So let's get to the conclusion on that one. Yeah, motion is denied. All right, next, motion for order requiring state to provide. This one's also wasn't going to go anywhere. This is where they said the non-statutory aggravators to prove beyond a reasonable doubt. This is kind of similar to the other argument with the grand jury, where it's just like trying to find kind of like archaic case law and what they're trying to say is like the non-statutory aggravators. Again, what is that? That's victim impact statements. They're saying that there should be a standard that needs to be proved beyond a reasonable doubt, and that's impossible. But that's not going to go anywhere. There's just no way it's going to go anywhere. So it only applies to the statutory aggravating factors. But I understand that you have to make the argument. I'm surprised the judge is actually even putting this much into that one. Yeah, it's denied. There we go. All right, here we go. This is the one I was most interested in. The motion to trifurcate and apply the rules of evidence to the eligibility phase. It's funny because I just mentioned that, how the rules of evidence don't apply. And I'm like, that seems really not correct to me. Yeah. While defendant acknowledges that Idaho's death penalty scheme provides two phases, a guilt phase and a penalty phase, he contends it must be trifurcated to ensure his constitutional rights are maintained. To this end, he argues the penalty phase should be divided into two parts, one addressing whether he is eligible for the death penalty, which means there is proof of a statutory aggravator beyond a reasonable doubt. okay? And one determining the appropriate punishment, which is weighing all relevant evidence. If the state is permitted to present all evidence relevant to both statutory and non-statutory aggravating circumstances at one time, defendant contends a jury may be confused as to what evidence applies to what statutory aggravator and misapply the evidence. Trifurcating would ensure that the jurors consider the appropriate aggravator at the appropriate time. He also contends that once trifurcated, the Idaho rules of evidence should apply to the eligibility phase, given that it is akin to a guilt phase. Here's what I think is going on here. I think what they want is, again, like I pointed out earlier, the victim impact statements, right? We know that the standard set forth in every trial at this juncture, right? Maybe things will change in the future, but right now, the victim impact statements are given before the sentencing is handed down by the judge. Whether it's a death penalty case or not, or whatever, right? The victim impact statements are given. And then, and when it's not a death penalty case, right? Then the judge renders a sentence. Now, why am I mentioning this? Because the thing is that the judges more than likely already have outlined what their sentence is going to be based on the statutes, based on the evidence, based on all these things. And they're more than likely not going to change that sentence based on emotional testimony from the victims. And I think rightfully so, right? And one reason that I take issue with this is because when you look at things like cold cases, right? Where a case is finally find somebody because of the DNA way years later, right? The victims of those crimes, right, likely aren't going to have anybody that can come in and give victim impact statements. So think of it this way, guys. Think about in any trial, if for those of you guys who were watching the for Lake and Riley, there was any trial where you've got a victim and then there's one person after another. They've got tons of friends and family coming in and giving these emotional victim impact statements as they, that's as they should. I just think it needs to happen at a different time, as we'll get to, right? But you imagine that, and then you imagine someone that's like a cold case, right, where it's been decades and there's nobody left, and that victim doesn't have anybody to come in and give an impact statement. Then how is it fair if we say we're going to allow the victim impact statements to then affect the sentence? How is that fair to people? Or people, doesn't even have to be a cold case. It could just be somebody who doesn't have a lot of family members, right? For whatever reason. Maybe they moved away, and I don't know. It could be anything, right? Not everybody has big families. Not everybody is a social butterfly. And the thing is that it shouldn't affect, like, the justice is for the victim, right? And so how many people are still alive, willing and able to come in and give an impact statement shouldn't have any bearing on what the victim suffered, in my opinion. Which is why I feel like the better plan here is to give victim impact statements after the judge, or if it's a death penalty case, the jury has rendered a sentence. And there's multiple reasons for that. One, it guarantees it would not impact the sentence. And two, and this is equally as important, right? If you want to see evidence of this, watch the sentencing in the Ezra McCandless trial, because in the Ezra McCandless trial, when they were doing the victim impact statements, right, as normal before the sentence is handed down, and in that case, her defense attorneys made multiple objections and interrupted people mid-sentence, and it was really gross. And they said things like, you have to address the court, you can't address the defendant, or this thing wasn't allowed. In other words, because of the fact that if victim impact statements are given before the sentence is rendered, there are still rules that do apply. Now, most of the time, you're not going to have people objecting like that. That was really, I don't think I've ever really seen that before. But the fact of the matter is, even if that's not the case, there are still limitations, sometimes even on length. Sometimes we'll see that, right? Where they have a certain length that they can give. And the thing is, because the sentence hasn't been given, the defendant still has rights, right? That's the thing. The defendant still has these rights. And so therefore, there are restrictions and limitations placed upon those victim impact statements. So in my view, it's even more fair for the victim impact statements for the victim's friends and family to be heard after the sentence is handed. Then they can speak freely. There can be no issues. There can be no objections, and it preserves it. Does this make sense to you guys? Like, this preserves it for everybody. Like, this ensures that a judge or jury is not swayed by emotional testimony unfairly, right? And and again, the unfairness being also to those who don't have people that can come in and speak on their behalf. It's unfair to them. But it also is more fair to the victims or family members and friends, in my view, where they don't have to have restrictions put on their statements. So here's what I'm getting at. I think that is what the defense team here is thinking. However, you can't make that as an argument. That would have to be, I think, that would have to come from the legislature. And so here's what's going on, right? And we see this all the time, where they're making an argument, right? Because it's the legally sound argument, but that's not the reason they're making the argument. And I think that's what's happening here. So what they're saying, right? In other words, what the defendant, right, his defense attorneys are arguing, that this is the best argument that they can make. Contends a jury, it's right here, contends a jury may be confused as to what evidence applies to what statutory aggravator and misapply the evidence. And that the motion to trifurcate here, trifurcating would ensure the jurors consider the appropriate evidence at the appropriate time. I don't think they really think that. I don't think that's the real issue. I don't think but again, I think that's the argument they can make. But the real reason is for the reasons I just gave. Because what will happen here is that in this death penalty case, they're going to hear all this emotional testimony, and you guys can probably imagine what will happen in this trial, right? When it comes to the victim impact statements and what we will hear. And imagine that if you're that jury, you hear all that, and then you go decide, right? So it's unfortunate that the argument that they have to make, legally speaking, is not a good argument, because I think that from a philosophical standpoint, like in a reasonable standpoint, it should be trifurcated. But again, for the reasons I mentioned, but that's not the argument they can make. The state responds that the defendant's position is simply one of public policy and ignores the plain language of Idaho Code and binding appellate decisions. It points out that the Idaho Code calls for a single sentencing proceeding, which has been the general practice. Again, like I've said, that's been the norm, right? Don't rock the boat. The state further points out that the defendant's proposition of leaving the presentation of mitigating evidence to the last phase would have the unintended consequence, I think this is supposed to say consequence, of highlighting aggravating evidence. This issue is a matter of first impression in Idaho. Having said that, Jay Logston said he has actually tried a case, although maybe it wasn't in Idaho, but he said he did try a case and that was trifurcated. So it's been done before, maybe it wasn't in Idaho. Balancing the benefits and detriments that may be posed by trifurcation, and considering trifurcation is an exception to the rule, the court will proceed in accordance with Idaho Code rather than depart an extra statutory Quixotic journey through trifurcation. Rude. Not even considering it. We don't need to read about the birth of bifurcated proceedings. He's going to deny it. That sucks. Pros and cons of the trifurcated approach. As in other capital schemes, the bifurcated approach is the default rule in Idaho, and as discussed, the one envisioned by statute. And again, that's why I said this has to come from the legislature, right? Statute, legislature. They write the rules. They write the statutes. That's why I said any changes is going to have to come from that, unfortunately. It necessarily results in a wide spectrum of evidence subject to different evidentiary standards being presented to the jury all at once. I mean, I don't think anyone's saying it shouldn't be bifurcated, right? Like that's, we know. In addition, courts and commentators contend bifurcation can lead to juror confusion over what evidence is relevant to what decision and what burden of proof applies. Oh my God. What this judge is saying, holy shit, what this judge is saying, dude, I was like, why is he already talking about people arguing that bifurcation is bad? Okay, here's what's going on here. Remember, like I just said, the argument that the defense team has to make, legally speaking, is not the real reason, but it's the argument they can make. And the argument that they're making is that the jury will be confused. So what he is saying, this is wild. The judge is responding with, well, if you're worried about jury confusion, There's plenty of case law and people contending that bifurcation can lead to confusion. So by that logic, should it just be all one phase? Wow. That's a logical fallacy. I'm trying to think which one is that. Is that the straw man argument? Let me look it up. This is a logical fallacy, in my opinion, right here. This is crazy. I know there's different. Let me just see. Logical fallacies. This is a logical fallacy. It's swapping the argument, and it's making an argument that they're not making. It is. Well, there's one called appeal to tradition. I would say that's what literally we see all the time in law. The appeal to tradition, it says this fallacy involves pointing to traditional practices or what has been done in the past to support a claim. But I mean, literally, that's what they do in everything in law. I would say that this is probably could be considered both straw man and false dilemma. So the false dilemma, this fallacy eliminates all possibilities except two that the speaker chooses, forcing the other person into a predetermined argument, right? That's why I'm saying why I think that applies here is because it's like forcing them to say, well, are you saying it shouldn't be bifurcated at all then? But the reason that the way he's even able to say that is because straw man. So straw man, that's misrepresenting or distorting someone's argument to make it easier to attack or refute. So I would say right now we're seeing at least two logical fallacies being applied here by this judge. This is wow. So right now, this is insane. He is giving all the supporting evidence against bifurcating the judges. Well, not because he thinks it shouldn't be bifurcated, but just to try to disprove that argument, wow, about it confusing the jury. This is dumb. I don't even have words, you guys. I don't have words. Oh, man. It should footnote. Okay, hold on. Where has he got this footnote? Holy mackerel. Wow. Okay, to pretend that such victim impact evidence is not potentially unfairly prejudicial on issues to which it has little or no probative value is simply not realistic. I disagree. Even if the court were to give a careful limiting instruction, rather, such potent emotional evidence is a quintessential example of information likely to cause a jury to make a determination on an unrelated issue on the improper basis of inflamed emotion and bias. Well, yeah, that's what I've been saying. Sympathetic or antipathetic, depending on whether one is considering the defendant or victim's families. But then that's from this case law with this footnote 32. But then what footnote 32 says, it should be noted that the scope of victim impact testimony in Idaho is limited. And he's going to discuss that. I can't wait to see what they say. They say, but you know what, y'all, this proves my point, right? Remember what I said? The victim impact testimony is limited. This is my point. How is that fair then to the victim's family members and right? The victim impact, how is that fair to them? This is my point. So this is the thing. If courts want to continue to get victim impact testimony in before a sentence is handed down, like I just said, they're going to have to limit it, and there's limitations, right? That's the only way they can get it in. But then how is that fair to the victim's friends and family members, right? Why can we not just have it happen after the sentence and it solves all the problems, and then it doesn't have to be limited? Rather than, it just blows my mind. Rather than saying, okay, yeah, we can see the victim impact testimony, that could be a problem like that. Yeah, that's as it says here, right? It could cause a jury to make a determination on an unrelated issue on the improper basis of inflamed emotion and bias. Rather than saying, yeah, that's a problem here, why don't we just let them have their statements after we do the sentence? Instead of that, they're like, yeah, let's limit the victim's friends and families. How does that make any sense? And how is that fair to anybody? How is that fair to the defendant? And how is that fair to the people making the impact statements? You guys, I get really, this to me is just insane. I don't know. It makes me want to do something about it, but I don't know what I can do other than read these documents. So there we go. And again, in addition, courts and commentators contend bifurcation can lead to juror confusion over what evidence is relevant to what decision and what burden of proof applies. This is the judge showing, hey, I'm going to just go ahead with these logical fallacies because I'm the judge. Wow. Oh, man. Oh, man. Okay, let's skip ahead. So trifurcation is not warranted, he says. Defendant contends that operating under a bifurcated model in this case would cause substantial prejudice, confuse the jury, and violate his constitutional rights. He anticipates there will be substantial evidence, of non-statutory aggravation. Yup, including emotionally charged victim impact evidence and evidence of his own past and character, none of which is relevant to the 4 statutory aggravators charged by the state. He argues he will be unfairly prejudiced by the free-for-all presentation of statutory and non-statutory aggravating evidence at once. There is good chance the jury will be unable to segregate the evidence properly. Right. So this is the real reason that it needs to be trifurcated, as I mentioned, despite careful instructions. Moreover, he contends that because the eligibility decision is under a ring akin to the guilt phase, it should be subjected to the rules of evidence. And that's why they made that argument earlier for the neutral fact finder, because they want the rules of evidence to apply. The court, however, does not believe trifurcation will be beneficial, as the defendant hopes. Since it was enacted, Idaho Code has contemplated a bifurcated process in capital cases. Thus, trifurcation, even if permissible under Idaho statutory law, is an exception, not the rule. The court does not find the exception is warranted here. First, as the defendant acknowledges, the Idaho Supreme Court has long held that the rules of evidence do not apply at capital sentencing proceedings. Instead, and again, that was the weaker of the. I think it should apply personally, but that I didn't think that was going to go anywhere. But he's addressing that first, even though it's the weaker of the arguments, right? I'm not. So I want to get to the part. What's he going to say about the victim impact statements with the emotional part? So he's going over the rules of evidence part still here. He's addressing that first, instead of addressing the better argument first. Okay. The most compelling reason to trifurcate the proceedings is to avoid the risk that the victim impact statements may color the jury's perception of the mitigating evidence. There is no question that the victim impact evidence will be heart-wrenching and difficult to hear. Look at this, dude. Hey, Judge Stickler, I have your solution. You want to know what you should do? I've got your solution. Right here. He says, however, victims have rights as well, including the right to be heard at sentencing. Yeah, I agree. It doesn't mean they have to be heard before you hand the sentence. Look at this, guys. There is a solution to all of this, man. The right to be heard at sentencing. Why not? Can they come to the proceeding? The judge hands over, they do the aggravating factors, right? The jury, in this case, it's death penalty, right? The jury deliberates, they decide what they decide or whatever. And after the sentence is determined, at sentencing, guess what? The victim's rights, they can come and make all their impact statements, and they can have no limitations. Further, there are several precautions to guard against undue prejudice. First, in homicides, only immediate family members may offer victim impact statements. That must be specific to Idaho, because we see all the time when it's friends of the family. Further, the family members are statutorily limited in what they can say. Now, how is that fair to them? How's that fair to them? And this is my point. They are not permitted to offer characterizations or opinions about the crime, about the defendant, or about the appropriate sentence. So they can't, it sounds like the limitations would be, he deserves the death penalty or something like that. I will say, I would fully expect some of these victims to either not be aware of these limitations or be aware of these limitations, but in the heat of the emotion, say something like, this evil monster deserves the death penalty. I would bet my arm on it, okay? That someone will say almost verbatim, that evil monster deserves the death penalty. And what does that do? That breaks all of these rules. They're not permitted to offer characterizations, evil monster, or opinions about the crime, evil monster, or about the defendant and the appropriate sentence, deserves the death penalty. But I guarantee you somebody will say that. I just do. And once they say it, as they say, the cat's out of the bag, can't put the toothpaste back in the tube, all the other sayings, right? The jury hears it, and then the defense can object and move to strike. But at that point, right? It says they are merely presented to present, quote, a quick glimpse of the life of the defendant, the life that the defendant chose to extinguish. We'll see. Again, I don't know why they think the solution was to just limit the victim's family members and friends rather than say, hey, let's just have this go after the sentence. But whatever. Again, I'm just a broken record now. Finally, this court can further impose restrictions on victim impact evidence to ensure it's not unduly prejudicial. But how is that fair to them? The court may require that victim impact statements be presented in writing prior to the sentencing hearing so they can be reviewed to ensure. So now again, and they did this, like in the Ezra McCandless trial, they did this. They had their statements in writing. They did all this, but even still, people would, and rightfully so, and this is my point, right? Rightfully so, people would be reading it, they would get emotional, and they would add something that wasn't in writing, and then as they're crying, right, they get yelled at by a defense attorney. But so it's a problem for everybody, you see? The court may also instruct the victims to read from their statements and avoid emotional outbursts. Again, we saw that with that trial, they were reading from their statements, but every now and again they would, elaborate, as it were. The court does not find that trifurcation is necessary to protect the defendant's rights. This one's not going anywhere. This was the speedy trial. Actually, this was probably I was shocked when I saw they even made this motion. I'm not even going to go. We'll just see. He's going to deny it. There's no way. There's no way. We knew this wasn't going anywhere. I thought the trifurcation had the strongest chance. And then after that, I thought it was the motion to strike the HAC aggravator and the utter disregard aggravator. I thought those were their strongest ones. Contemporary standards of decency. That's the one that's dealing with the treaties, international treaties. That's not going to go anywhere. Means of execution. The argument there, that's not going to go anywhere either because it's not ripe. That's what they're going to say. Assuming the defendant is convicted and the death penalty is imposed, it would likely be at least a decade before he's executed. That's the not right part. To decide now as to the constitutionality of any given method would amount to an advisory opinion. Not right. Avoidance of defense distress is not a basis to contravene well-settled rules of justiciability. Consequently, Mr. fails. Here's with the firing squad. Now, okay. Clearly he's denying all of these. So this is one thing, though. They didn't give another suggestion. But again, logical fallacy here, right? Because part of what both the state and the court has been saying is it's not ripe. It's not ripe. It's not ripe. So you can't be making this argument now to as to the method. But then they turn around and say, well, you didn't give an alternate method. So which one is it? Is it not ripe, or did they not give an alternate method? Because now that you can't have both. It's just hypocritical, among other things. So, like, if I were the defense team, I would argue, well, how can we provide an alternative if it's not ripe, right? So, yeah. Order. Here we go. Based on the foregoing analysis, defendant's death penalty motions are hereby denied. It is so ordered. And there it is. And there you have it, guys. So, in summary, what did we talk about today? We talked about the Adobe is just having a day. We talked about the state asking for more help. They want more assistance from the Attorney General's office. I'm sure that will be granted. I would be surprised if it's not. What does that mean? Well, it means they need help. You guys can let me know what you think it means, right? They need more help. They had already brought in, a couple, I think they named 2 people in the initial motion from April of 2023. It's two things. They need extra people and they need extra resources. So money, right? So they're asking for the same again, more people, more resources. It'll be interesting to see what happens, because I wonder, in the interest of justice and fairness, right? Does that mean that then the defense team gets more resources and more people? I wonder how that works. And probably I wouldn't think so, because I know they're like completely separate branches and they have their whole system. And actually, I know that we heard them discuss it, right? The way that they handle it in Idaho with the public defenders and court-appointed counsel and all that, they just went through a revision. And I think it might actually still be in the process of the revision on how all that works. And it was actually one of the reasons why they were asking for a continuance, because she was concerned that they may not be able to stay on. I mean, didn't seem like that, but it was a possibility given the restructuring or whatever. But anyway, but I could see them making that argument. I don't know if they will, but I wouldn't be surprised. So yeah. So anyway, state's asking for more resources, and then we covered all the death penalty. Again, I focused on the ones that I thought were the strongest for the defense, which was striking the well, at first it was the arbitrariness factor, right? The failure to narrow the class, and then it was the two of the aggravating factors I thought were the strongest were the HAC and the utter disregard, and then of course the motion to trifurcate. But everything was denied; all of it was denied. I just hope that someday somebody, and I wish it for every state, right? That the legislature looks at this and looks at fairness to everybody, including the victims, fans, and family members, and says, hey, they have a right to speak at sentencing. Why can't it be after the sentence? And then solves everybody's problems. It's in the interest of justice, right? I mean, I don't know why it's not happened yet, but we do know the wheels of justice turn slow, and we do know that they are slow to make changes. I don't know why I don't hear more people. I've never heard anybody else say this. Like I've never heard anyone else even ask this question or make this suggestion, and I find that so surprising. And the other thing that I've never heard anybody mention is the point that I made about the cold cases, right? That for those victims that don't have living relatives or friends or family, right, or people that aren't cold cases but just don't have an influx of people, whatever, how it's unfair to them, right? That if you're saying that these victim impact statements should influence a sentence, right? And I've never heard anybody even bring that up. Anyway, so let alone, I think that the part about the emotional influence is obvious, but no one ever takes it further than that and looks at the rest of the other issues or the solutions. For whatever reason, I don't ever hear people talk about it, but I'm really passionate about it, as you guys can probably tell. I think it matters. So anyway, this should redirect you guys into the next live stream, which is Casey Anthony, and I timed it out actually pretty well. We will start out with a recap from the previous episode, and we've got lots of fun stuff in store for that. It's going to be this episode's going to be the Google searches, and I will tell you guys that the state brings in an expert witness, a forensics computer guy. This is one of the best cross-examinations in recent memory, and I don't take that lightly, right? The way he gets completely destroyed, because par for the course in this case, in this trial, for no one that's watched this trial, please, like, this is a really interesting trial. The state, witness after witness, does not get out ahead of anything. They don't get out ahead of anything. So anyway, it's going to be really interesting. It's kind of a long and arduous direct, and then the cross-examination is like, holy shit. And then after that, we're going to hear from some crime scene people, and then we're going to get into actually the first of the many medical examiners or forensic pathologists. Can you believe it? There's more than one. I've never seen this in a trial. There's more than one. They've got like, I haven't even finished going through all of it yet. They've got multiple, which is odd, right? So we're going to get to that today as well. So anyway, without further ado, I'm going to go ahead and end this, and it should hopefully redirect you guys. But thanks so much for being here. Let me know what you think in the comments about all this. And hopefully I'll see you guys in the next stream, and I will go ahead and roll the outro.